Put that there. You're welcome.
So what you're saying is that you should have I got what I'm power. I don't think it's it sucks though when you just don't even get to put on really are.
That's upsetting to me, but I did threaten her not to get here. I mean, not everybody.
Hey, Reese, how you doing?
Good, how you doing?
Good.
I'm good.
You're welcome.
I got a question. I've got, if you can't, that's fine, I get it. Amanda Owens got to retain me. Talk to him. You got to do a special. Get from the other side. Got to sell July 1st.
Yeah.
I'm on vacation. I go over now, in this case, I might agree to move it or.
Not unless you file a notice of appearance.
Okay. I'll follow my notice of appearance. I get a call.
Yeah, I mean, I don't, you know, if she's just come in, if she just come in.
So she wrote a check, she done all that, we talked, and then I started looking at the date.
Yeah.
She left.
Let me call him and make sure, cause I'm trying to remember if there's some emergent scenario.
The next date I've got is the 30th and the 5th. Those are the next court dates that I've got down that I could hit. There's July 9th and the 30th. Suzanne, or not, finishing up a 4-day trial at 9. I can do the 30th and August 5th. That's a way
Well, the
down,
9th,
so.
I have 3 matters in Cheatham County in front of Judge Wood.
That's a way
Yeah,
down.
this stuff, I'm good.
Yeah, let me just see if there's some emergent scenario or something we can do.
Yeah, okay. That'd be great. I appreciate you.
Yeah, I just don't remember right off the top of my head. It's just typical.
Yeah, that's what I got.
But I don't know that there's not some underlying thing.
Okay.
You know, the houses are, you know, I just don't know. But let me call Judge A later on today, and I'll get back at you. And let you know.
It's next week, so I'm leaving, so we've got
Yeah.
a week. I like to give her money back till we get going. You know, after. Somebody else?
I was representing.
Still have those old Suzanne Lampley. Unless we body headed up.
Oh, it's bad.
She was playing part of it. I just walked off.
I
said,
did
"Man, you can't get out of
another
way."
motion. I just did another motion this time.
Yeah.
You know, she's got the cussing, she's got the belittling. And then, I was going back in the order that she wasn't to discuss the case, neither one of them discussed the case. So I filed for the 14th.
Yeah.
So,
She did about 3 things there in about 2 sentences. I just walked on. I don't even want to listen to it.
Yeah, I'm not going.
Can't get out of her own way. You know.
And then, I mean, and it could have been, you know, like I said, and the press is like, well, what do you expect me to do? I mean, what do you think? You know, I mean, that was the worst. Oh, yeah, he makes 2 statements.
Okay.
And they, I mean, it is, you know, he's got that little speech.
Yeah.
Well, Mama, I don't know what that, but, you know, and I mean, it just will rip the entire. It's like.
Heart wrenching. Yeah.
It just turns out it's going to work.
Yeah.
Because, yeah, Preston. Just that little speech of them, the teary eye.
Yeah.
And I'm like, and he goes, Miss Jennifer, I need you to hear this.
What?
Preston told me, just Jennifer, I need you to hear
Oh,
something.
here it is. Yeah.
And I said, what is it? Send it to me. He said, I wish they were both with each other. That's why.
I heard that I walked off. I had talked to her. I just said I can't call her because I'm gonna say something. She's gonna report me over. And I'm gonna get in trouble for it. I gotta calm down long enough to hear the whole thing. So I'm not gonna calm back down long enough to call.
Well, it
One of those.
ends with Preston saying, Mama, what do you expect me to do? Just. I mean, I mean, it, oh. Yeah.
I know you're not.
You know, I told her. Go get you another water. Let's just draw a line right there. I'm saying. We're okay.
Well, I mean, effectively, this is a case where you and I, it's not gone to the point, I don't think we have, but our clients' hatred and stupidity has led that they're gonna be homeless, broke, and it will be lucky if he doesn't refer the case to, he'll be in jail. And I
Tell me nice, one of those hot saw you carrying all that and tried to.
Thank you.
Partnership services.
Come down to you and me having an argument. Can our serve in alternate sentences? So at least while he's in jail, she can watch the kids. While she's in jail.
And it's gonna, and when you talk about reportable offenses, it's gonna take every bit of an ounce that I have not stand up as a judge. The only thing I'm asking is and you make them you send them to jail at the exact same time, and then you require the jail to have adjoining cells. They're married, put them in the same cell.
Put them in the same cell.
Put them in the same cell, they're not divorced yet. Put them in the same cell and make them serve them time together. And that's the only that's the only thing just.
Well, I go then come back out and exercise.
Well, hey.
Yeah.
Day late, a dollar short, the bank's gonna cut it. SBA is gonna be cut.
All right. The County Chancery Court is now in session. The Honorable Judge David Wolf, present presiding. All who have business drawn here be heard. God bless the state of the United States and this honorable court. You may be seated.
All right, good morning. We'll start with the call of the docket.
2026 CV 64 regarding the adoption of Anna Joy Winter.
We have not seen Ms. Coffinberry yet, so we're going to need to pass your case. Have you heard from her this morning? Okay.
I messaged her just now, Judge, to see where she is.
All right.
We're doing the same.
Just, we're going to see if we can round her up. So y'all just have a seat. When she's here, we'll come back to you.
2024 CV 195 Nation Star Mortgage LLC versus Dina Marie Baker and the Secretary of Housing and Urban Development.
Good morning, Your Honor.
Good morning.
Alex Colwell here for Nation Star. Your Honor, I have a quick update on this case. The defendant filed bankruptcy since the last status conference.
Okay.
So the case is still up in the air. I haven't gotten any authority from my client as to what we should dismiss it.
We'll just pass your motion on the docket without prejudice, but right now it doesn't appear you can take any action until the bankruptcy court deals with it. So, all right. Thank you.
Thank you.
2026 CV 33 regarding the conservatorship of Jacob Frederick Couch by Charles Couch Jr. and Karen Couch.
And then
Good
we're
morning.
ready if you'd like to take that up.
Let's go ahead and take it up. All right, everybody's going to testify. If you'll raise your right hand and be placed under oath.
Do you solemnly swear or affirm that the testimony you shall not give in this case shall be the truth, the whole truth, and nothing but the truth to help you God?
You all could state your names.
Charles F. Couch Jr.
Karen L. Couch.
Okay, and you filed a petition to be appointed as conservators for your son, correct? Is this your son sitting with you today?
Yes,
And does he live with you?
yes, he does.
Okay, has he lived with you for his entire life?
Yes, he has.
And is there any reason, medically speaking, he's not able to care for himself or make his own decisions?
Well, he has Down syndrome and he's on the autism spectrum.
So you're asking for all the rights of the conservator to be transferred to you by this court?
Yes, we are.
You filed a proposed property management plan,
Yes,
and you were proposing to manage any assets belonging to Jacob or income according to that plan?
yes,
Okay. And his adult siblings have been notified of this petition, correct?
yes,
Okay. And you've also filed a medical examination report that was signed by his physician.
yes.
Your Honor, Mr. Chapman has also submitted a guardian ad litem report.
Yeah, I just reviewed that. So anything you want to add to that report?
No, Your Honor. Other than Jacob has a great DVD collection. So,
I was looking for the medical report, but I do find it attached to the original petition. So obviously this is an appropriate disposition of this situation, and no one is better suited to serve as the co-conservators than the parents. So I'm happy that you're both willing to step up and take that responsibility. You have an order, Ms.
Yes,
Foster?
Your Honor. I also have my affidavit as well, which was just filed this morning.
Let me just say this. Obviously, this is a permanent medical condition, and while the law may say that you should have to come back in and submit an affidavit or a letter from a doctor or a report annually to sustain this conservatorship, I see no reason that you should have to go through that process. So I'm going to waive the medical report. I'm going to strike through where it says on an annual basis as to the financial and medical status. I'm going to strike through the medical status. Okay. I will initial that, Ms. Foster. So.
Thank you.
Well, I have signed your order.
Thank you, Your Honor.
thank you, Judge.
Good luck to you.
2026 CV 42 regarding the conservatorship of Flora Pyburn by Waverly SNF Healthcare LLC.
We're also waiting for Ms. Coffinberry, who's the guardian ad litem for that case, so we'll need to pass it. She should be here shortly.
2021 CV 67 regarding Regina Johnson.
Very also. She did message me and say she's on her way about speaking.
2023 CV 155 regarding the conservatorship of Jerry Crone.
Ms. Andrea Sinclair. have a motion to withdraw. Apparently, Ms. Sinclair is of the opinion that she filed a motion and not appear, but wait, she's in the waiting room. I'll take that back. Ms. Sinclair, if you can hear me, you have been admitted to the hearing and we're taking up your matter, so I'm going to ask you to unmute and to turn on your video.
Thank you, Your Honor. Can you see and hear me?
I can see you and hear you.
Thank you so
I
much.
spoke ill of you a moment ago. Not really, but I thought maybe you had thought you just had to file the motion to withdraw and not appear, so I apologize.
No, thank
you
you
have
for hearing me virtually today, Your Honor.
No problem. You have a motion to withdraw, but also you have an order granting the costs and fees in this case. And this is if I recall correctly, this is the conservatorship of Jared Crone.
Yes, Your Honor.
Is there any opposition to this motion regarding the costs and fees or the motion to withdraw? Anyone here in the courtroom? No one here to oppose it, so I will grant both of your requests.
Thank you very much, Your Honor. I believe I've submitted proposed orders for both of those, but please let me know if we need to file those.
Submitted proposed orders and I will sign them today. So
Thank you very much, Your Honor. May I be excused?
you may.
Thank you so much.
Go back. Since Ms. Coffenberry, we passed a couple of your matters. Let's go ahead and start back over on the docket since one of them was on the docket.
Sorry.
2026 CV 64 regarding the adoption of Anna Joy Winters.
Morning, Your Honor. I apologize. I was late. I thought it was going to take me less time to get here than it actually did. So this is just a petition for adult adoption. Miss Anna Joy Winters wishes for her stepfather, Brian Gardner Rains, to adopt her. He has basically served as his father, as her father for most of her entire life. And so now we just want to acknowledge that relationship and make it official. Everyone has signed the petition.
Right, if everyone will raise your right hand who is going to testify in this case.
Do you solemnly swear or affirm that the testimony you shall not give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
All right, Ms. Coffenberry, you may put on your proof.
All right, if you could, sir, please state your name.
Brian Rains.
And are you the stepfather of Miss Anna Joy Winters?
Yes, ma'am.
And have you all discussed that you would like to adopt her, make her officially your daughter?
Oh, for a long time.
And you're married to her mother, who's with us here, Nicole Rains. Yeah. Okay. And you've signed consent adoption, correct? And if you could, your name. Go ahead and say your name.
Anna Winters.
And this is your stepfather. Yeah. You would like him to officially be your father. Yeah. Okay. And you understand that by doing that, that Michael Hinson will no longer have any relationship to you. And you would like the judge to go ahead and approve that today and change your name to Anna Joy Rains.
I don't know if it's just a happy coincidence or whatever, but this adoption is set the day after Father's Day, but perhaps it was fitting that it could have been set for today anyway. I would like to compliment you, Mr. Rains, because being a stepfather is one of the more difficult things to do, to balance trying to be a parent without overstepping your bounds in a situation. And it's a high compliment to you that you have formed such a bond with your stepdaughter that she wants you to be her father in every sense of the word. So you understand that if I grant this adoption today, that you will be her father the same as if she was your biological child in every way, shape, form, and fashion. That she will be able to inherit from you and you from her if God forbid something happened. That she will have the responsibility, moral responsibility to take care of you when you get old and infirm. So,
Coming out on short end of the stick on that.
but and Ms. Winters, do you understand as well that this is going to create a bond between you and your stepfather? He will no longer be your stepfather. He will be your father. You understand that? And you wish to have that bond created. Well, you are, I'm not going to ask you how old you are, but you are legally an adult, correct? Over 18. You have the right to consent. So with your consent, I'm happy to grant an adoption. So, you have an order, Mr. Coffenberry.
I just read this on your sign.
Twenty 42 regarding the conservatorship of Florence Hyburn by Waverly Estimate Healthcare LLC.
We have Ms. Coffenberry. There she is. Let's see if she's been over. All right. Petition for appointment of a conservator over a person's property of someone in Waverly Healthcare. SNF Healthcare, is that correct?
Yes, Your Honor.
Do you have anybody that's going to testify about the situation?
I do not, Your Honor. Just the report of decision submitted along with the petition.
Your Honor, I've submitted my report on it. Yes. The proposed conservator is here, Your Honor.
So we have a medical report that details that the respondent has dementia, cognitive communication deficit, anxiety, unsteadiness, muscle weakness, and malnutrition.
Yes, Your Honor. Her dementia is relatively severe. She knows who she is, but she often can't remember the names of her children or her former husband or exactly where she is.
I have your affidavit of fees, Ms. Carpenter, but I don't see a copy of the reports in here unless I've overlooked it.
I have a copy of the report, Your Honor.
I think it would be good to file a copy because unless I'm listed,
Send it over to the clerk.
Did you send it to me?
I sent it to him.
We weren't here Friday.
I know.
Let me see.
Okay.
I have an extra
Is
copy.
that
of
an
the
extra
report.
copy?
It's
Extra copy.
double-sided, I'm sorry.
All right. So she had a monkey named Squeegee.
Yes, Your Honor.
She remembers that.
She wrote all about her animals, and all the children's animals.
Sometimes animals are more loyal than children, so. All right, I've reviewed this, but I'm gonna have this report marked. And if the new one, if your original comes in, so be it, but I'm gonna go ahead and mark this as.
That's fine.
Mark it as an exhibit. All right, I found that this is appropriate that, to be a conservator appointed, may I see that? So.
Honor, and Miss Piper doesn't have any real assets except for potentially Social Security. And so we I recommend waive this conservator. I believe that the nursing home is going to be the representative payee for anything that she receives on. The main thing is just get her to be qualified for tenure.
Do we have someone that can, you were appointed as the attorney ad litem, do we have someone in mind to appoint as a conservator?
Miss Mason here.
And you're willing to serve as the conservator of this individual?
Yes, sir.
We will appoint you to do that. I don't see, since there are no assets, there's any bond required or property management, since she has no assets. And Social Security, I assume, is going to pay her stay at the healthcare facility. All right. First, you'll submit your orders, please.
Yes, I have a short.
Phyllis, let me ask you to sign this order, please. I think you signed it.
I apologize about that.
All right. I always repeat what Judge Robert Birch used to tell me when I submitted an order that I hadn't signed. If you don't care enough about signing your orders, then why would I? So.
That's a good point. I'll make sure to have it signed next time.
That's not yours.
Thank you very much.
2021 CV 67 regarding Regina Clark and Johnson.
Talk this in. We can talk for a minute. I think we can just talk just a minute.
All right, we'll come back to it.
2026 CV 149 Andrea Daniel versus William Daniel.
You skipped over Shaver.
2026 CV 19 Summer Shaver versus Jason Shaver.
Robert?
I represent Mr. Shaver, Your Honor. We're here today on a motion default, which took place on May the 27th. Judge Turnbull set it for today to give the defendant 2 more weeks to answer, and he has not replied or answered.
Jason Cody Shaver in the courtroom. All right. All those who are going to testify, raise your right hand. Let's place you under oath.
Do you solemnly swear or affirm that the testimony you shall now give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
All right, thank you.
Well, that's just about my default. He's supposed to be here. He answered by the 22nd.
Your default judgment is granted, so you want to put on your proof regarding the divorce?
you're Miss Shaver, Summer Sarah Shaver, is that right? And Jason, your husband, has been a kind of an addictive person all over their marriage, is that right? Has he abused you and the two daughters? Oh, well, you're saying that.
You'll step up a little closer to that microphone. There you go.
He's never physically hit me, but he is mentally abusive.
But he does have a problem with addiction.
Yes, sir.
Has he supported you any?
Yes, sir.
That's your name.
My name is Morgan Mayberry.
And how do you know?
She's my best friend.
Is she? Okay. Have you've heard what you said?
Yes.
Is it all true?
Yes, and I would also like to point out that he actually has child abuse charges for one of the victims.
One of these children.
Yeah, and then also he has neglect charges for getting drunk with the kids.
He has a no contact with the kids and the show. Out of general subject. That's your name?
James Dawson.
James, I believe you're
I'm the father.
the father.
Yes.
You know your daughter to be truthful,
Yes.
and you've heard what she said,
Yes.
and you've heard what the witness said.
Yes.
Are they true?
I agree with both of those.
Okay. She needs to away from this case.
Yes.
Michelle, if you'll step back in front of the microphone, I've got a couple of questions. You have filed a proposed permanent parenting plan that basically makes you the primary residential parent and does not provide for your husband, the father of the children, to have any contact with the children right now. It's my understanding that based on his abuse of one or more of the children, that there is some sort of a restraining order or a protective order out of another court.
Yes, sir. The DA had granted a 2-year no contact between me and the kids.
Right, and is there a pending criminal case against him right now?
Yes, ma'am.
Let's let her answer, sir.
Okay.
I believe so.
And that's for abuse of one of your children?
No, sir. He got drunk behind the steering wheel and passed out with my kids inside the house.
Right. So he was behind the steering wheel of the vehicle while the children were inside the house alone?
Yes,
How old are the kids?
my daughter will be 9 next month, and my son will be 7 in August.
Right. And he is the biological father of the kids. Do you and Mr. Shaver own any real property?
Just my vehicle.
Just what?
Just my vehicle.
All right. Well, that's personal property, so you don't own any land, or in other words. So you have your vehicle, but is that in your name only?
I believe he was the co-signer on it.
Okay, but you're gonna keep that vehicle, is that
Yes,
correct? Right.
She wants custody of the children, Your Honor, and the parenting plan sets out the child support. It's been filed with the court.
The parenting plan, your final decree provides for him to have supervised visitation. Is that what you're agreeable to?
Yes, sir. Yes, sir. I would like the supervised visitation only with me, so I cannot trust anybody else.
That's in there, Your Honor.
I know it's in the final decree. I'm looking at the parenting plan that was proposed, and I want to make sure the parenting plan is more important because sometimes they get separated from the final decree of divorce. And it is that parenting plan. And under subsection B, it says the mother shall have responsibility for the care of the child or children except for the following times when the father and the other parent shall have responsibility. The father shall have supervised visitation with the party's minor children until the father, and further, the father will contact the mother 1 week prior to schedule his visitation. So even despite those issues you talked about, you're willing to supervises visitation with the children?
Yes, sir. My kids are super young, and as long as I can be there to supervise, I don't mind.
Yeah. Anything else, Mr. Bradley?
No, Your Honor.
Granted the default judgment, if she is awarded a divorce on the grounds of inappropriate marital conduct, I will adopt her proposed parenting plan, which has previously been filed with the court, and I'm going to sign that one that was filed with the court, unless you have another copy that you want me to sign.
I have one here.
Always better to have a separate copy attached to the final decree. So.
Didn't hear that, Your Honor.
What does he do for a living, Ms. Shaver? What does he do for a living?
Honestly.
Well, I always prefer honestly rather than something else, but you can.
Doesn't do anything.
I think she's been the breadwinner of the house.
So you have down here that he is required to pay child support, and he was not at this point.
We calculated
Based
according
on
to the guidelines, and
you imputed income to him based on the guidelines. Is that correct?
Yes, sir. I believe I gave them my taxes for 2 years ago.
Right. Where's the place for me to sign on this proposed parenting plan? That will attach it and mark it, file as a part of this final decree. All right, thank you.
thank you. Yeah, she has that question, Your Honor, can she?
So previously, as stated in the divorce papers, I had said that I wanted to keep the last name Shaver. I believe there's too much attached to this last name, and I would like to get rid of it.
Well, it's your name. You can change it to whatever you want. So
Her maiden name returned, is that right?
your final decree does not provide that. Mr. Bradley, all you need to do is file an amended final decree that does change her name. Just add that specific provision, and that way it'll save you having to file a new action to change your name.
We don't have to have a hearing or anything.
No, just submit an amended final decree changing the name, and I'll take care of it.
Thank you, Judge.
Right.
Thank y'all.
Yes.
Twenty 149, Andrea Daniel versus William Daniel.
Your Honor, this is my motion for a wage assignment. Your Honor, we were here before the court back in February and took a default judgment against Mr. Daniel, modified the residential schedule and the child support. The court ordered that Mr. Daniel's new child support be effective in February. He's failed to pay anything. So I did not include in the default a request for a wage assignment, so I filed this motion just requesting that I issue a wage assignment so that we can ensure that his child support is paid.
Then your request for a wage assignment will be granted without opposition.
Thank you, Your Honor. Okay.
2026 CV 60 regarding the conservatorship of Emmanuel Devaney, Richard Devaney.
After you've been admitted, I'm going to ask you to turn on your video and unmute if you can hear me.
Sir, if you will keep the hands on the office, please.
So
Can you hear me, Your Honor?
I'm going to ask you the same thing I always ask your mentor, Mr. Flanagan. Are you driving at the moment?
No, sir. No, sir. I'm in park. I can improve that there. I'm in park.
We have established that Mr. Spratt is in park, so we may proceed.
Thank you, Your Honor. I'm here on behalf of Mr. Odell. This is his, Mr. Devaney's petition for appointment of conservator.
You'll raise your right hand. Let's place you on the road.
Do you solemnly swear or affirm that the testimony you shall not give in this case shall be the truth, the whole truth, and nothing but the truth to help you God?
Can you state your name for the record?
Richard Devaney.
And what is your relationship with the respondent, Mr. Emmanuel?
I'm his daddy.
Okay. And does he have a relationship with his mother?
No, man.
Okay. So his next closest relative would be his sister, Miss Ruthie Brown.
Yes, ma'am.
And was she made aware of this proceeding?
Yes, ma'am.
Okay. And did she express any objection to this proceeding?
No.
Your son, Mr. Devaney, he's been diagnosed with schizophrenia. Is that correct?
As far as I know, yes, ma'am.
Okay. And you are seeking to be appointed as conservator at this time on a temporary basis in order to make all decisions for Mr. Devaney. Is that correct?
Yes, ma'am.
And does Mr. Devaney have any kind of property?
My son?
Yes.
No, ma'am. Well, he's got a vehicle.
He has a vehicle. Okay. Does he have any kind of income of any sort?
No, ma'am.
Okay. Are you asking to make all decisions on Mr. Devaney's behalf?
Yeah, mental ones, you know, for him to get help, however I want to say it.
Is he in the hospital right now?
Yes.
Middle Tennessee?
Yes,
I don't show, Ms. Lowe, I don't show a copy of any medical reports. Are we going to be filing some?
I believe it was fax filed on Thursday, but we can absolutely file that.
Well, let's just make sure, we'll follow up on it, but I need to make sure there is a report filed. So.
he has been admitted there 4 or 5 times already.
I saw that in the pleading that you filed.
Sir?
I saw that in the pleading that you filed that he had been admitted to Middle Tennessee 4 or 5 times.
Yes.
So we do have a physician's report from an examination that was completed on June 18th. We can file that today if it is not filed. And I believe that Mr. Spratt went and served and met with Mr. Devaney this past weekend.
All right, Mr. Spratt, you were appointed to be the guardian ad litem, so can you enlighten me? I don't have a written report, but are you able to give me insight as to what your interaction with Mr. Devaney was?
Yes, Your Honor. I met with Mr. Devaney yesterday at Middle Tennessee Mental Health Institute. And I've reviewed the report. I also believe Mr. Odell's office filed that Thursday. I haven't done my own report, but I met with him for about an hour yesterday. He's diagnosed. The diagnosis is fairly evident. He first said he wanted to consent to this, and he revoked that consent later. But there were some incoherent statements during that revocation. So I certainly advised him. I served him with this suit also, and I had given him the notice of hearing as well. Advised him of his rights. He did not request an attorney ad litem. I explained what that was, but as of now, he opposes the suit. I informed him that my position would be that the conservatorship be granted, and I informed him of what my role was as the guardian ad litem. I explained the notice of rights to him specifically, and he had some paranoid concerns. So it's my position it should be granted. I don't know if the court wants to set a review date or something of that nature. But
so do you have any questions for Mr. Spratt?
Nothing further. Mr. Spratt, did he disclose any kind of property that he has possession of?
Well, as far as that went, and I'm glad you asked that. He told me that he owned the house on Sunset Drive, and that he had $800,000 in the bank. At the same time, he knew that I was Jelly Roll's cousin. So
I didn't know that.
I didn't either, Judge. But it was.
I can see the resemblance. Other than the tattoos, I can see the resemblance. So.
Well, it was a very, very fluid transition from consent to non-consent.
I have experience in dealing with clients who were suffering from paranoid delusion. paranoid schizophrenia. And I think it is clear that with the medical report that obviously has been filed, I haven't seen it, but subject to that, to my review of that, it is clear to me that he is in need of a conservator, and his father is the appropriate person to serve in that. I do think it's probably a good idea, from, as Mr. Spratt had suggested, that we go ahead and set a review date. Do you have a date, say maybe 60 days down the road? Is that,
And we had prepared an order to appoint him on a temporary basis with a review
the
hearing.
temporary, that's what I was going to suggest. Let's do it on a temporary basis, subject to, sometimes people who suffer from schizophrenia, if they get appropriate medication, stay on it, they're functional. But obviously if he's not, trying to help himself, then he's going to need somebody to try to help him with that. But
August 27th or 28th.
August 27th or 28th, Mr. Spratt, do you have your calendar anywhere?
I don't, but I believe that'll be, either one of those will be fine, Your Honor. I can do a
August
report, in case I have to have somebody stand in that day. I'll do a written report.
I would suggest that, so that if somebody does have to stand in for you in case you're in concert or whatever. So.
I'm just a stagehand.
Well, I would think your cousin would give you a better job under those circumstances. It explains a lot about why we never can get you in court.
That's right.
Mr. Spratt, need to sign this order on your behalf.
Yes, absolutely. And for the record, Your Honor, I have the return summons, the original, and I'll bring that to Waverly today for the file.
All right.
I can email Madam Clerk a copy of it if we need to do that, but I will bring it to Waverly today.
If you're bringing it today, that'll be sufficient. All right. I will sign the order. Tell your cousin Jelly Roll that we all said hello. So.
Thank you, Judge.
I will do it. I will do it, Judge. And, hopefully somebody can save me, as he says. So. Thank you, Your Honor.
And I sign the order.
Thank you.
2026 CV 62 Casey Shote versus Mark Dozier.
Mr. Dozier served. We don't have service back that he has actually been served with your petition. So there was an ex parte order of protection issued by Judge Lockhart Nash on June the 11th, and that one has not been, we don't have the return that he's actually been served and notified to be here. So what I'm going to suggest is this will remain in full force and effect, but it will be continued until we can get him served, and then you'll be given notice. Okay.
All right. Thank you so much.
Thank you. We'll get it later.
2025 CV2 Daniel Jones versus Jennifer Jones.
Yeah, that's here for a hearing and they just stepped out. Probably need to mark after discussion just briefly if we could.
All right.
2021 CV 99 Christy Thornberry versus Tristan Thornberry.
That's Mr. Duke's motion for formal visitation. I understood it was set today, maybe to get a date to have that actually heard rather than have this heard, but she's out, so.
All right. So we'll come back to it. I'm gonna, let's run through and see what else. So how long do you think your Jones case is gonna take to try if we have to have the hearing? I assume you will.
The rest of the day. We have division of assets in custody. Adoption.
Just the case that I've heard before.
You've had one other hearing, maybe two other hearings in it.
Right.
So that's why I think we just wanted to have a brief conference to narrow down the issues on what we're going to do, consistent with the prior order that we have for your signature today.
All right, then we also have Gabriella Gallion versus James Gallion.
Yes, Your Honor, those are my motions. I filed motions to adopt a temporary parenting plan. And this is Ms. Stevenson from the Nashville Bar. She's also filed reciprocal motions.
Okay.
Yes, Your Honor, and I apologize if they were in the style that this court is used to. I'm from the Dickson County Bar, and typically when we get these motions filed, we file counter motions as their own motion. I'm not sure if that's how the court likes them down here, but that's why we filed them separately.
We're all here asking for the same thing, just different relief.
It seems to be fairly apparent that you all are asking for the same thing, so.
Yes.
All right, well, you're behind the Jones versus Jones case, which I'm told is gonna take all day to try, so you and Ms. Roberts may want to talk about your case. I'm gonna take a recess, and let you all try to discuss whatever. And if, are you wanting to have a conference with Ms. Duke and myself?
I think so. Yeah, Ms. Duke and I've got an order prepared that needs to be entered from the last hearing that we need to provide that. I don't know if she's passed that up to you. But, okay, we've got to get that entered and then we'll be ready to, there was an issue about selling the house, so.
All right, well, I'm gonna take a recess to allow you and Ms. Duke, I'll be in chambers if you want to come.
And then there's still the Miss McLeod's case. Somebody went out and struck a dog off the vet collar. She's out.
There's two.
Well, yeah, usually. Yeah. Okay, this is all. He's our court order.
So nice to meet you.
Yeah, let me get your name.
Yes, absolutely. Here, I got a card. Is
That's
that
fine.
better?
Yeah, that'll work great. Do you want to share today? Well, I guess.
I think it depends. I'm not sure.
Okay.
Well, again, it's, I mean, there's, if we could resolve the custody issue, I don't know how much summarized Hillary is, I'm going.
Yeah.
Unfortunately enough.
Yeah, at least I'm not from the town, you know, I'm sorry. But when I drove past that side, I should jump.
Oh, there she is.
Those people dirty.
I moved further away.
I thought we were just getting a date.
Well, he stood up to say that.
And that's what I said.
He stood
I
up.
didn't bring.
You asked me, because I continue to try to say, could, and.
It's not.
It's not right.
That's, I just didn't have my client come.
Well, and my client's out of town. You know, my client supervised.
Yeah.
I
Let's all go and just get another date.
I'm not really involved, but I am from.
So you are involved because they quit.
But the other thing, I'll tell you.
They're out of town.
Yeah, they're in.
We got a parent plan.
Okay. Well, let's just get a date.
Well, they're not, but they're not operating, if you're willing to operate them.
I'll move it. Visitation's at the moment discretion. There was some things he had to do.
No,
You were asking for grandparent visitation, so we gave him that and let him supervise.
No.
Unless he goes and gets
no,
like.
and it's not working.
No, you got, my client is supervising your client's visitation, your client's visitation.
Yeah.
My client, but we haven't proceeded on the grandparent supervision. Yeah. Yeah, because it's his visitation, but my client has to supervise. And so she wants just to have alone time. He wants to have alone time, and my client's saying, look, I submitting myself to the jurisdiction of court. It's gonna be here. And so let's just get a date and then I can come back and get the rest of my stuff done.
I'll be back.
How you doing, JP?
I've got to go grab a quick thing.
I forgot last week. I'm like, well, we'll do it Monday. All right. Yeah.
Yes, ma'am. Yes, ma'am. No, I wish y'all. I miss that little Katie. Dr. G, we call I had a new fitness gym for you. Better than the old. Well, I gave you some tools for urination. I think it's slowing down. That's what I need, because when we're making me get up too much at night. After the operation, I had 4 prescriptions. Okay. Really good. How do I get in touch with you? How do I get in touch with you? Well, I haven't been taking, the only thing I've been taking is that low sugar. Well, I don't know. What's her name? call the nurse and I need to know. I got out of, I was my primary care doctor. Over there in Charlotte. And they moved to another field over well, he don't do anything right anyway. Also, I lost all faith in him. Oh, yeah. He ain't never gonna get invited. Never. Don't wanna go. That was all on fault. Got nothing to do with it. Do it. No. It'd be good to me. Setting up the appointment. What? I'd rather do that, you know, I try to keep, I live so far away. Nurse, you are, keep it, or this will talk to you. Okay. And I carry the cell phone on me all the time, I'll answer. Nice talking to you, Dave.
So I don't know which way. I've been the first. She didn't want you first. You did not knock them all out. Once we have three of them. Yeah, that's just really good. Thank you. That's- Yeah. You said you know how to so. Oh, yeah, they're every year. The best part. Yeah, you don't have to go prep the first time. We're running a lot of before I could get it from public classes. They were supposed to bring. That's.
She won't mind. Good, how are you? Good to see you. Congrats on the third. Yeah.
Yeah.
Me and my dad were talking about it the other day. I was like, I feel like she's been pregnant forever.
It does feel like
Yeah.
that, just one time.
Yeah, I've just seen you pregnant forever. Yeah.
I think I'm done
You
now.
done now? Is the final
Three's
count?
good.
Yeah, that's enough.
And we didn't have butter. It was Get a refresher. It is. It makes it less sweet. Yeah, it makes it good and it really brings out the taste of apples. Yeah.
Mm-hmm.
Or it's a good day, long day.
Hope not.
I don't know. Okay, that's where it is so far.
Maybe all of them are so scared the other ones are gonna go, they'll work all of them. I'll be here for a while.
Yeah. Nicole and I were about a long period about numbers, which would possibly have been fine with me.
Yeah, that sounds great.
So is the joy. People got it. Final divorce. And emotion. It's a heritage. Did you hear my total for each person? You guys have at least a whole me. Is this your doctor? Oh no, it's Jennifer's. My bad. Let me take it right back. What's down here? Oh. Make sure that what's the not that automatically. Jones, please.
I was just talking about you. About how I've been doting on you, just thinking like for the count. There is, it was that.
Goes out there and cheat.
Yes. Yes, he's doing a trial coach. So the next thing, I'm sorry. There's fireworks. And then there's this. I think I just injured myself. This is liability. Yeah, well, two of these weird church pieces with the sticking out. Yeah. Hard.
Eventually, it's getting heavier and heavier every year, it seems like.
So.
I think I know the reason I told.
Yeah, I live in cash for that.
Yeah, I think I'm gonna have to do something.
Sometimes the things people do, I'm like, so maybe you should send that to somebody. So cool. I'm not be kidnapping for you. Someone come along. I didn't see that one. Yeah. Oh. Yes, get the baby back. Emergency testing or any testing, whatever. Crazy eyes to crazy. So, I'll praise the Lord. But same time, that is tough. Well, I charged her for it, but I was like, I did not advise her about that. Well, it is. It's a one page anyway. She's not having to judge for something wrong. It's under notice. He's wrong about this. She's he phone was statute. My bad. So lunchtime, I'm hungry.
Almost there.
Yes. I do it. Restroom. Yeah. Every time, just like the next dinner's front. This is like, where are you going? I'm like, I'm like, I'm in the food council. Don't you gotta do your part? You gotta do your part. Okay. So we're almost done. Can I give these to you? One of these is just my over here witness exhibit. Hey, Jones is moved to the 30th of July in Dickson. July 30th in Charlotte. I think, I gotta figure it out. Well, no.
Hola.
Yeah.
We had meetings with the counsel for the Jones versus Jones case, and we've set that for a final hearing. And then we've also set a hearing in the Thornberry versus Thornberry, so those two are off today's docket. And that brings us to Gabriella Gallion. I'm sorry, we need to take up your case, is that correct? Yours and Ms. McLeod's.
If we can, Your Honor, Ms. McLeod and I had an opportunity to go over some of these things together with Ms. Lisa. And I think we've narrowed it down and we have an agreement about how this fee is going to be reimbursed.
Yes, Judge, and before we get started, I wanted to call the court's attention to the affidavit of Jim Foster. There's a typographical error in it, and that I put that he was appointed as conservator on paragraph 3, and that's a typo. He was never appointed conservator in this matter. Just want to clear that up in the courtroom.
Okay.
And Your Honor, I had filed a motion to approve some fees. And after discussion with my client and with Ms. Lynn, who's the guardian ad litem, we have come to the following agreements. As far as Ms. Lisa, we've agreed that she can be reimbursed $1,333, which is for, let's see if I got this right, for medication assistance for the ward. $1,239, which is mortgage payment for the ward's residents, which they covered for her when she fell behind. There's also a fee of $1,960 for the phone bill for the ward that my client has paid. There's attorney's fees in the amount of $2,500, which will pay to me. And then there is mileage expenses in the amount of $14,352.00, which accounts for 4 years of driving back and forth between Franklin and then Spring Hill and here in McHugh. And she has kept a record of all those and has submitted those to the guardian ad litem.
Pages and pages of that documentation, and I agree with that.
And Mr. Jim Foster is not here. He's not going to come in today. He did sign this affidavit. He had incurred expenses of $25,651 in the form of renovations for the ward's home, which was later sold, and the money deposited in the conservatorship account. We've also reviewed those and provided receipts of those expenses. He was married to Miss Faye, who was co-conservator in this case, but she sadly passed away. This money came out of their joint accounts. And that I think the guardian ad litem is okay with them being reimbursed that amount only. So we have proof that they did expend that money.
And the house did sell for $185,000, so there should be sufficient funds for that, and also for those funds are expended.
And the last thing is that we have also talked about Ms. Lynn's fees. We have agreed to add to an order, if Your Honor approves these expenses, that my client will also pay $1,906.50 in her fees as well.
All right, so everybody's in agreement with this?
Yes, yes, sir.
It's all in agreement, then I will approve of that.
Under oath, Your Honor, testify anything?
You what?
Do you want to put her under oath for any reason, or?
Yeah, let's go ahead and do that. If you want to raise your right hand and be placed under oath.
Do you solemnly swear or affirm that the testimony you shall not give in this case will be the truth, all truth, and nothing but the truth, so help you God?
Could you state your full name, please?
Lisa Taylor Gray.
And are you a co-conservator for Miss Regina Johnson?
I am.
And who is she to you?
She's my aunt.
Your mom's sister? Okay. And Miss Faye passed away. That was your mother?
Correct.
When did she pass away?
July 3rd, 2024.
And you've heard everything myself and Miss Lena have told the judge here today. Is that all true and correct to the best of your knowledge?
Yes, it is.
Okay. Right, Judge.
Submit your order.
Thank
Judge, I will
you.
do that.
Thank you.
Concludes my business.
Galleon. All right, we're down to our last case, Gabriella Galleon versus James Galleon.
Mr. Gallion. I'm sorry.
Good to see you. All about I know, right? Thank you.
All right, we have motions by both parties essentially asking for identical situation where just that parenting time and child support can then allotted. And then this, Robert, you had filed the initial motion to adopt a parenting plan for temporary in possession of the marital residence. You
Yes,
filed
Your
those on June the 8th. And then Ms. Stevenson, you filed yours on the 12th. So we'll proceed with first in time, first in right, or do you want to go by the parties, whoever the plaintiffs are?
I don't have a preference, Your Honor. It's,
Ms. Stevenson, well, you're the plaintiff, so we'll let you put on your proof first. So you wish to make an opening statement?
That is no problem with me. Good afternoon, Your Honor. Chelsea Stevenson for Ms. Galligan. As you know, there have been several motions filed that are relatively identical in nature. However, I think realistically what this case, or at least these motions are going to hinge on, is the no contact order that is currently in place. The father is currently facing charges for simple possession of paraphernalia, and domestic violence, wherein the mother is the victim. And the father was forcibly removed from the marital home after committing an alleged assault on the mother when the children were all present. During this alleged assault, the police were also able to discover several items of drug paraphernalia and marijuana and other illicit substances. Father admitted to police that they were his and that they all belonged to him and that he is a drug user. These charges are currently pending in the General Sessions Court here in Humphreys County, and there is a no contact order as a result of the domestic violence charges that forbids father from coming in or around the mother's marital residence. In the actual reports filed by the police officers in regards to that case, mother's address is listed as the marital address. She does not have any other addresses at which she can reside. And father is explicitly ordered not to come around that residence. Now, since he was removed from the home, father has paid absolutely nothing in support whatsoever for his children. He has not paid any of the bills for the home. He has not provided anything at all to mother to support the children. She has raised them entirely on her own since he was removed from the home. Now,
when was he removed from the home?
it's been more than a month, Your Honor. It's been almost 2. So, as a result,
29th of April.
Yes, Your Honor. So, as a result of this, when father first appeared in the criminal case about a couple of weeks ago, I would say, he attempted to have this bond restriction that is currently in place, preventing him from contacting the mother, removed on the basis of the fact that he wanted to speak to his children. After this was presented in front of Judge Lockhart Mash, Judge Lockhart, my client, appeared without counsel She was only a victim in that case.
This was in general sessions.
It was not
Well,
Judge
no,
Walker
I'm
Mash. Not Judge Walker Mash, I apologize. That's, I
Judge Walker
apologize.
Mash is the circuit judge. That would have been.
Judge
Judge
Maples.
Bradley.
It was Judge Maples, Your Honor, my apologies, it was just a slip up. But either way, Judge Maples aggressively questioned my client about whether or not the children could talk to their father, and my client testified that she did not feel that it was appropriate for the father to exercise any parenting time with the minor children because they were present when the attack happened, and they are also victims of abuse at father's hands. There has been a DCS case opened in the past when father abused one of the older children to the point where he appeared at school with bruises that were significant enough to cause the teachers to call DCS. Father admitted to my client that he did hit the child. However, he said he didn't mean to hit him as hard as he did. Nevertheless, there is a long and demonstrated history of abuse on father's part against both my client and the minor children. For those reasons, we do not feel that it is in any way appropriate for him to exercise parenting time while these charges are pending against him. And that if he is ever to exercise parenting time, he should be subjected to drug testing and he should be subjected to supervision, as he's clearly a very, very violent individual who is prone to take out his anger and rage on my client and the children. It's also important for this court to know that 2 of these children are not his biological children. They're my client's biological children from a previous relationship. Only 2 of the minor children that exist in this household are his biological children. The youngest 2, who are only 1 and 2. They cannot be without their mother for extended periods of time at this age, and he has never exercised any parenting time alone with these children. Mother has always exercised the vast majority of parenting time and is a victim of father's abuse, just like the other children. Mother has also submitted a notarized income and expense statement for this court to review pursuant to the local rules of Humphreys County Chancery Court that states exactly what her costs are, what she makes, and what she needs. As per our income and expense statement, she has a demonstrated need of at least $3,500 a month. While we know that that may not be something possible for father to reach, as it is quite a large number, we do know that he is gainfully employed and more than able to provide the support that she needs to raise the children. Quite frankly, it was shocking to us to see a motion for exclusive possession on the home and for support, knowing the fact that father has been explicitly banned from going to this house and has paid nothing whatsoever towards the minor children's care since he's left the home. Additionally, we would assume that somebody who has abused children to this nature and is now facing charges in a court of law regarding these abuse allegations would consider the fact that this no contact order is in place for a reason. Safety and assurance that these children will be able to live happy lives unadulterated by the abuse of the defendant. We would ask that Your Honor put in an order that prevents father from contacting the minor children until the adjudication of the abuse allegations. And we would ask that if he is granted any parenting time at any time in this case, that he be subjected to regular drug testing and supervision, at least at the beginning, so that we can ensure that the children will be safe and well. Thank you, Your Honor.
Robert?
Your Honor, I don't know what case she's talking about. There are smatterings of truth in what counsel said, but far from the reality of what's going on. These parties have been married, they have 2 children. My client has not requested anything except from the 2 children. Yes, this woman has 2 other children that she's had allegations of abuse against. But again, there's no allegation of abuse of my client against these children whatsoever. I was present before Judge Maples when counsel was not, so I take significant issue with her not even being present in the courtroom stating what went on in court, because it was far from the truth about what went on. Judge Maple, I filed a motion to be relieved to modify the bonding restrictions so that he could have contact with the minor children. Mrs. Gallion appeared and said, nope, I'm not willing to talk about it. Why would I give him visitation? And I'm not going to do it. And so again, it was Judge Maples did question and said, were the children, I've read this affidavit, the children were not involved in the abuse. And she entered an order that I can present to the court during the hearing, that the Chancery Court has full reign to modify the bond conditions to allow to allow whatever contact this court does as far as the children are concerned, that the bond conditions will be modified pursuant to whatever this court rules. But Ms. Gallion was using the criminal process. It was obvious to Judge Maples as well as to myself that Mrs. Gallion was using the criminal court position to position herself with this court, as many alleged victims do. There was an allegation previously at Department of Children's Services that was unfounded. Councils uniquely left that off, that it was unfounded. And again, it always is just amazing to me that someone will come before the court and talk about how someone has been abusive to these children for such a long period of time. She puts in her affidavit that they're locked in the rooms, they're doing this, they're doing that. Yet she never stood up and protected these children one time until she decides to have this child, to have him arrested. Not one time has she ever made the allegation of abuse in the past, other than the report to the Department of Children's Services. That came back as unfounded. So if a modicum of what counsel says is true, that she failed to protect these children, that her client failed to protect these children from these heinous things that she's alleging my client supposedly did, she's worse than he is, because she had the opportunity to protect and didn't do it. But I say none of it is true, Your Honor. My client works. He works at the Golf Club of Tennessee. In their hospitality section, she's a waitress. He has provided care for these children. The very idea of saying he's never been alone with the children, and to have a sexist comment to state that children can't be removed from their mothers because they're 1 and 2 years of age. I mean, what century are we living in? Again, tender years doctrine was abolished in the state of Tennessee, I believe in 1969, a few years after my birth. So that's never been the law in the state of Tennessee during my tenure as an attorney. He has provided care for the children. His father was the babysitter. He was present during this so-called abuse allegation that she took place, which she came up, jerked the keys out of his hand when he was trying to go to work, saying, "You're not taking the car." There is no allegation. My client had, as I would say, gas station drugs, perfectly legal in the home. She lied, told the police that where they were in the home. They said, "Are these yours?" He said, "Yeah, they're mine," but there's not been any testing. For an officer of this court to come in and make an allegation that those were illegal drugs without even knowing it, I think is inappropriate.
Objection, Your Honor. We're not here to relitigate the criminal case. These are charges that are pending before the court. It's not me or Ms. Roberts or any of our clients' job to make charges or decide what charges should be. The police decided to charge him with simple possession of an illicit substance, not us.
Based on the allegation, the sworn statement of her client stating that it was marijuana.
When I have to make a decision regarding the custody of minor children, the two parties basically are opening their lives entirely for me to examine any evidence that relates to their fitness and their credibility. So therefore, anything having to do with these criminal charges would be relevant. It goes to the issue of whether or not they're a fit parent to either have custody. So
Certainly, Your
your
Honor.
objection is overruled.
Certainly, Your Honor, but the only thing that I
Your
really.
objection is overruled.
This is a different objection, Your Honor. My secondary objection would be that as counsel, it's certainly not relevant to get up in front of a court of law and say or state that she didn't protect her kids when she's a victim, or that her attorney is lying or saying things to this court that are incorrect. I'm an officer of the court just the same as Ms. Roberts is, and I did not say those things about Ms. Roberts. So I would ask that we try to stay on the facts rather than launching personal attacks. Thank you.
And your objection as to the basis for Ms. Roberts characterizing your client as being untruthful or failing to protect is overruled, because this is, again, as I've said, a case where the two of you are going to essentially try to gut each other in the courtroom, so that each of you will try to show the worst aspects of the other so that you can obtain an advantage. This court's job is to look to the best interest of the minor children. And as far as any sort of personal attacks of the attorneys, I prefer that it not take place in this courtroom. But I also understand that both of you are very capable lawyers, and I will allow you to try your case. But let's keep it to the facts of the case rather than what.
And Your Honor, thank you, Your Honor. I appreciate it. And Your Honor, Mrs. Stevens is going on what her client told her just as much as I'm going on what my client told me. That's from that perspective. But when it goes into a court of law that I was there and Ms. Stevenson was not, is what I take issue with, on saying what was said when she was not present by the court. And that was the issue that I had on her stating I wanted the court to make clear that she was not present in the court and witness, and that Judge Maples specifically ruled that the residential.
I'm going to decide this case so that everybody understands. Right. I'm going to decide this case based on the evidence before me today and what I find to be the best interest of the minor children. It is not going to be decided based on what another judge has or has not said or has not heard. It will be heard and decided by me from the witness stand today. And while statements of lawyers and their opening statements are allowed to try to give me an idea of what their case is going to be about, the statements of lawyers are not evidence. Neither Ms. Stevenson nor Ms. Roberts' statements are going to be, I'm speaking to your clients now, neither Ms. Stevenson or Ms. Roberts' statements to me about what has or has not transpired is going to be considered by me as evidence. It is their indication of what they think the case is about and what they want me to do. I'm going to decide this case based on, put it in my hands, I'm going to decide it based on what I think is the best for your children. And neither one of you may like what I do at the end of this day. So we will go forward from that. Ms. Roberts, anything further?
That's it, Your Honor. And again, what we're requesting, again, if she's going to get possession of the home, she needs to pay for it. He will be entitled if he gets possession of the home. He will get it. There has been no ruling of the General Sessions Court on who has possession of the home. So I want to make that clear. The court has not ruled who has possession of the home. It's wherever she's living. The General Sessions Court has sole province about a no contact order with her. I do not disagree with that, but all of the other issues are not before the General Sessions Court. And any indication that they are is incorrect.
All right, Ms. Stevenson, is the rule requested? The rule has been requested, then we'll need to have anyone who's going to be a witness other than the parties go outside of the courtroom and remain outside of the courtroom until you are called to testify. You're not to discuss the testimony of any other witness until you yourself have testified. Counsel are under continuing duty to ensure that the rule is complied with.
And Your Honor, we just have one more concern that we'd like to address. Pursuant to the local rules of Houston or of Humphreys County Chancery Court, we were supposed to each have filed a notarized income and expense statement as well as a copy of our proposed parenting plan, and we have not received either of those things from the opposing party. It's difficult for us to move forward and decide exactly what support amount is appropriate if we don't have any sort of statement that is detailing what he makes, what he.
Mr. Stevenson, that is a rule that is in the local rules, but it is a rule that is more observed in its breach than in its compliance. So it's not unusual to have that situation happen. I will take a recess for you to discuss with Ms. Roberts if that information is available, and that will give you an opportunity to be prepared. We'll take a 15-minute recess.
Great, thank you, Your Honor.
All rise.
I'll get it to you. We have got the, I called your office repeated times asking for a copy of the petition. I had prepared. Yeah. We got, I came down here to get, I was getting ready to file a complaint for divorce. Okay, I was getting a complaint for divorce.
Here's why.
And then y'all, I found out that you were representing her. Okay, I found that out in a roundabout way, just to let you know. When I was in court, I understand, and I'm saying this in front of both of them, if it's okay with you. She had gone up here to seek a order of protection and talked with Stephanie in there. I think Stephanie told her inappropriate information and told her that she couldn't get one because there was a bond condition downstairs. I think she went back downstairs and talked to one of the ladies downstairs, and they said, no, that's a civil matter, you can get it. So she got some, your client got some very inappropriate information.
Not like, you didn't do.
You didn't know, she didn't do anything
Someone
wrong.
told you the wrong info.
They were giving her the wrong info. At that point in time, when I found out about it, I did some snooping, and that's when I found out that she had, at some point in time, and again, this may be incorrect, when we appeared on that, she may have told me what your name was and she had retained.
Okay.
Then I reached out and your sister, or whoever said, yes, I've got a complaint, I've sent it to Waverly.
Yes.
So I took my complaint and waited. Then I called and said, hey, have you got it? We haven't got a stamp file. When I say call, please, maybe a text, maybe an email.
I've got it.
But said, no, we haven't got it back. So I called down here and said, the minute you get it in the mail, can you send it to me? So they sent it to me before y'all sent it to me.
Yes, because.
So I was trying to see what was alleged so I could change mine into an answer and counter complaint.
Got it.
Okay, and I didn't get it, so that's why the pleadings are such.
So here was the.
And then, so that's, it was just a snail mail.
We're not used to that. So we originally tried following it not by mail.
This is the parent.
But, with all of this.
Right, but that's where it was, I had done a complaint for divorce and had it ready, and then I had to change it into an answer and a counter complaint. So that slowed down the process on getting it. So that's where we were both getting back and forth, because that's where we had not done.
And so we were sitting here. Yeah, I think we're just waiting for this to come back, so I appreciate you.
So that's why we got it. So we got the answer from the counter complaint that has not been, we went on it. Our motions actually got here before your answer counter complaint. I don't even, so that's where, if he said that mine would file first, well, technically mine would file first, but there was no file to file me. I mean, because you hadn't, I had thought since you had mailed yours, I mailed mine thinking that yours would go and then mine would go, but mine got filed before yours did, but there was no file. I don't know how they created file.
I can't with the mail. It's like sometimes my stuff will get there the next day, sometimes it won't get there till like 3 months later, and I don't have any way to learn. It's crazy. But,
And he has sent me his paycheck that he sent Friday after we had left. Right, I know, just hang on. So I had provided him with an income expense statement, and he did not give it back to me. So where is it? Where is it? I gave you a form for that. Oh, it's So I'm going to give you this as a paycheck. This is his, he gets paid bi-weekly, $3,070.38. Bi-weekly. I'm going to go make you a copy of this. The 22nd. 6/22. All right. Now, as I understand it, they rent the home, right? You don't own that home.
They own it.
They own it. They own it. It's in joint names.
Yes.
Well, I think probably. Yeah, okay, let me go out and make copies of this for her, and let's talk a minute to see what we can do. Okay, so you just. And that's what that's. But I'm not. Just stay here, you know, what I'm gonna ask you to do, let me, hang on. Would you rather stay in here and him go out, or would you go out and stay in here? Okay, yeah, I didn't know. You stay in here. If you have to leave, I'm gonna tell one of the officers, okay, because I don't want any violations of the no contact, okay? So you just stay here, okay? Okay, it's not set. We got the date it's set, and it was set on. Okay, that's what my first. Okay, that's the first, I'm sorry, it's one of those, I was doing some things one time, so I'm gonna call it up to get your set, because it was just on what you said. Okay.
And so that's the day that.
That's the final hearing, that's it. That's it. Yes, we need to get together between now and then, so now. All the office schedule. Sometime we may, we probably said it sometime.
We're working on getting all that.
Well, I know, we're gonna get all that stuff together. Okay. All right, you said it.
It is relevant. Okay, we'll get it. Okay. Thank you.
Huh? Oh, we haven't set for hearing. Just give me the per diem. We set for hearing on, yeah, come get, let me give you these hearing dates, Austin.
Yeah, you remember me?
Okay. If you would write down, we have James versus James on October 1st at 10:30. We have a Thornberry, and I'll get you the style of it, but it's a grandparent visitation case, and I'm with Hillary and Reese are arguing over custody, and we're doing grandparent visitation on October 5th. Waverly. But these are all Waverly. Butler versus Butler, October 26th. Hedge versus Hedge, September 9th. Those are all Waverly. Now, Jones has been moved to the 30th of July.
Yeah, I got that one.
But it's a Waverly case to be heard in Dickson. So that's got all of the stuff right there. Okay? We're good. What I'm gonna do, we'll try to talk to resolve everything. And she stays in the house. You get this question kids several days during the week in the afternoons, and then overnight from Sunday.
Going back to the house.
If she doesn't want
Yeah.
it. Y'all can't live there together.
No, I know that, yeah.
I mean, so one of y'all gonna have to buy each other out of the house. You're just as good with her buying you out as you buying her out. Correct? Whoever's gonna pay the most.
Yep.
So we need to talk about whether she can refinance it or you can refinance it. If she can't refinance it, you wanna buy it from her. If she can refinance it, she can buy it from you. And then we need to get you some contact with the kids on a temporary basis until we can get that criminal crap taken care of, get it listed, and then come back in and do a 50-50 plan. Okay, but we can't do a 50-50 plan as long as you got him. Okay.
So tomorrow's case. Gonna be big day.
No, I don't think. I'm glad you asked, but that was Anna 8:30 down here.
8:30.
Well, she never, she starts toward at 8:30, but we don't, you know, she never, she started at 8:30. There's several cases on the docket. And it will probably take likely 15 minutes because my clock plugged her up.
So it won't take long.
No.
Okay, because I have a 1 PM in Charlotte.
No, it will, my client, well, it would have taken long had my client not taken positive for meth. So there you go.
Excellent, yeah.
Yeah, so that kind of put a quietus on me asking for unsupervised visitation.
Yeah, it is.
Okay. Lost my.
Chris?
Give you guys some privacy. Okay, here we go. Let me see.
I think it is muted, Jennifer.
Resend this. For hearing.
August 30th, is that the date?
Huh?
August 10th? Is that the date?
10.
Okay, make sure I'll note it.
Your son's having surgery. But when you this is going, who has a clue? And something. He's got. Okay, you know, but you'd say that she tried to come reach out. They got procedures, they, as a surgery, is a procedure. Procedure. So it's good. You're going to procedure. That you're going to start. Is that okay with you? Good deal. Well, that's what I have to You just will see. Okay, let me go.
I also bought the clothes and shoes.
Let me see if there's any time that you can see them today. Or short. And then you'll get me, you'll sign up, because you're off today, so you can get online and get. You mind you and your dad just going over to the house and visit them in the house?
Yeah.
Your dad can go with you.
Yeah.
You can go there, say, just interested with us. So what we're gonna do, we're gonna announce we're moving this, we're gonna get your car return praise. You were stipulating agreeing that you're gonna do about anger management. You're gonna visit them today, you're gonna get proof that you signed up for anger management. And then Ms. Stevenson and I are gonna work out a residential schedule. Good with that? Okay, good deal. Let me go tell the judge
I can press the button.
to turn it off.
No, this is what calls Abby.
Oh, oh, Abby. Oh, that is Preston.
Yeah,
Okay,
she gave me the button, so press this when they're ready.
okay. The bond conditions are limited as it relates to any residential time. We're agreeing that you're gonna see the kids stay at the marital residence with her present. That's not a violation. The bond conditions are modified, but you can.
That was nice.
You can go to any medical procedure appointment with
It's
the kids.
convenient.
And that, the bond conditions will be modified. Something
She said, I'm gonna go get the judge. I
as
said,
it relates.
Yes, you did good.
"Ding."
I'm just gonna have to give you that every time now.
You cannot have direct communication with her about anything else, nothing, just as it relates to kids. But that's gonna be reserved when we come back until we get that definitive schedule. And she's gonna get her schedule. And what I told her, I said, what I'd like to do is days that you're working late, that you get off at 2:30, so you can pick the kids up during the week and do things. You have every other, yeah, both of y'all will do that every other week. Y'all get to get babysitting. But during the week, if we can work something where you work from six to 2:30, 2:30. And if we could coordinate it to where she's working late. But you're not gonna work late necessarily. So, and so she can coordinate her work, but she's working late on every Monday. Then you can keep her, you know.
The latest I would, after.
But you have your company.
Oh, yeah.
But you need to decide, like I said, if she's not.
That's what I was.
So if she's not gonna have,
Right.
you don't want to sign your lease when you're with her.
That's, I've already been.
Well, yeah, because because they're gonna want a 6 month to a year lease. Okay,
I didn't want to
so we're
step
good.
somewhere.
We're good. Okay. So Abby, I'm gonna go tell the judge we're gonna get it now. So
Okay.
bye-bye. And I'm gonna come the long way, so they're good talking.
Get a text.
One o'clock, go to the house. Babysitter's gonna be there. You're gonna go visit, you have a couple hours to visit with the kids. Okay? Then, you got your bank signed up for, get me through, get it signed up.
All rise. Be seated.
Your Honor, thank you for giving us a break. We've reached a tentative agreement in this matter, subject to court's approval. What we're going to do, Your Honor, is that Ms. Stevenson and I are working towards trying to get a global settlement of this case taken care of. But again, we've got the criminal charges that are pending that need to be resolved. So what we're going to do, Your Honor, is that today Mr. Gallion's gonna be able to see the kids at the home beginning at 1 o'clock for 2 hours. His father's gonna accompany him. He's gonna visit in the home. The babysitter's gonna be there. Miss Gallion is not going, right? Where you go back to?
She'll be there, yes.
So the bond conditions will be modified, that he can exercise visitation at the home, and that will not be a violation of the bond conditions. My client is going to voluntarily sign up and take an anger management class. He's going to get that signed up today. I'm going to provide that proof to Ms. Stevenson. She's meeting with her client, and we're going to work towards getting a more expansive residential schedule. We just need to coordinate my client's off, his days off, when she works, and sometimes she has to work late, so we're going to try to coordinate that. And so we're going to try and get that done, but in the event that we can't do that, we're passing this case to July 10th so that we can try to get a global settlement. As far as the home is concerned, Mrs. Gallion is going to make a concerted effort to see whether she can purchase the home and buy Mr. Gallion out. She's going to see if she can do that in the next 7 days. Mr. Collier, presently, I'm going to contact him to get an appraisal of the home. Because again, neither one of them want to sign a year's lease if the other one's going to buy, because my client would like to buy the home out if she's not, but she's going to get the first option. If she can buy him out, that's great. And then he'll need to get a more permanent residence. But if she can't, he's going to purchase the home, and then she can understand and have time to get that. So that's one of the reasons why we're trying to get this passed a little bit. The bond conditions are going to be modified. Their youngest child is having a medical procedure on the 8th. And so we're modifying the bond conditions that says that it's not a violation of the bond conditions for them both to be present at any medical appointment or procedure of either of the children, of their children. And then we'll work towards getting that, and then get the bond condition modified that while the criminal charges are going, he cannot, and just reiterate on the record so that he understands, he cannot have any communication with Mrs. Gallion directly. They're going to meet today at the home. And then Ms. Stevens and I will probably enter supplemental order that they can meet to exchange the children, and that they can, what I would suggest is through written communication, keep each other apprised of the physical condition, doctor's appointments, things like that. I'm going to suggest a parenting app that they can communicate through so that it's a record. And then hopefully we can get the criminal charges resolved, and we can have a more full hearing on that matter.
Yes, and Your Honor, I just want to mention, the only reason we're not giving you the full schedule today is just because our clients have unique work schedules, and so we need to submit it to sit down and think about it. But otherwise, they
both work in the hospitality area, and so their schedules are not a Monday through Friday 8 to 5 type scenario. So we're trying to coordinate that, and we both need to get those schedules. He's been able to get another day off, and so I need to communicate that. So that's what we're trying to do.
Well, I'm happy to approve the agreement that's been reached between the two of you, and I'm glad that you were able to resolve that through your lawyers. Let me just say a couple of things to you right now. And Ms. Roberts has heard me say this before, but I'm going to say it again. Your children have two parents, not just one. And while we have a situation that has arisen where the father has created a situation allegedly where Mr. Gallion is not being allowed to see the children. Right now, those are just allegations. I understand you know what happened, and Mr. Gallion has his version of what happened. But the fact of the matter is that you have two children together, I think, and then you have some other children. But right now, you've got to focus on what's in the best interest of your children. If you have issues, and obviously there was some sort of problem, there usually is fire where there's smoke. You know, if there is a situation that has arisen simply because you let your temper get away from you, you need to address that. If you want to be a part of your children's lives, you need to fix the problems that are keeping you away from your children. If that is your anger issues, then voluntarily signing up for anger management classes is the best way to do it. Find a way to address those issues. If the two of you were not going to be together, then you need to find a way to tolerate each other down the road. Once the criminal things, all of these criminal things are subsided, you need to find a way to tolerate each other and to be able to be nice to each other. One way to do that is at some point you two had feelings for each other that led you to get married and led you to have children together. Whatever those feelings were, if you could try to remember them and try to recapture some of that, and let this anger and hostility that's existed. But, children need to grow up in a home without the threat of violence, without the threat of arguing and fussing and fighting. They need to have a stable environment. And if you can supply that for them because you get some help, then that's what we want. We want the children to have their father in their life. But by the same token, Mrs. Gallion and those children deserve to live in a situation where they're not walking on eggshells and worried about when dad's going to lose his temper and blow up again. They're not going to worry about, they don't want to have to worry about whether or not there's going to be some sort of an abuse and so forth. So it can be done. I can tell you that there are many instances where people have gotten their lives straightened out and they've gotten things taken care of. But we're going to do it according to your lawyers. You both have good lawyers and they're advocates for you and they'll give you advice. But the idea is to try to move you towards a more normal type situation so that your children can grow up together with the two of you co-parenting. Because if you don't, if this continues with that anger and hostility, you're going to basically ruin your children's lives. Think about it from now. If you were a child and you knew that mom and dad hated each other so badly that they couldn't even be together unsupervised, then they're going to grow up dreading every major event in their life, every birthday, every Christmas, every other holiday. When they get old enough to start graduating, they have graduations from kindergarten, from 5th grade, from 8th grade. They do a lot of graduations now. They're going to want you both there, but they're not going to want you both there if they're afraid that you're going to argue and fuss and fight. I see cases all the time where mom and dad can't even get along well enough to be at the same soccer field or the same baseball field. And you know who suffers in that situation? The children. And having your children suffer is not what this court wants to see happen. So keeping on with that analogy, eventually your children are going to get married or graduate from college, maybe graduate from high school. They're going to want you both there, hopefully. They're not going to want you both there fussing and fighting, because if you have the attitude that you hate each other so badly you can't even tolerate each other, you're going to not do anything but ruin those events for your children. They're going to be stressed, they're going to be anxious. And so I'm just suggesting that she has every right to feel that if you've been abusive towards them, verbally abusive or whatever it's been, then she has every right to expect that you're going to have to change your ways before the children can have an unsupervised situation with you or can be, safe with you. She has every right to feel that way. You have every right to think, I'm going to be the father that my children deserve. And if you are going to be the father that your children deserve, then you need to make the changes necessary to prevent anything else from happening. All of this is saying I'm not assuming any facts because I haven't heard any of the evidence. I'm not assuming that that any of these facts are true, but I'm trying to get you both to start thinking from a different perspective, to think about what's in the best interest of your children and down the road what's in their best interest versus what's necessarily going on right now. Anyway, I'm glad you were able to reach an agreement. I hope you'll take what I have to say and maybe understand that my only desire is to try to see that your children are well cared for and that they're protected. Because I can tell you from personal experience that growing up as a child, when you have a lot of that going on in your life, you remember those days. You may not remember much when you were the age of your children, but you can remember things that happened to you when you were that. My dad was pretty angry and abusive World War II veteran when he was younger, settled it up, got control of everything, quit drinking, and became an established member of society in our town where we grew up, and people would have never believed that he would have been like that. But you know what? I remember what it was like when he was angry, when he broke up furniture, when he did things that has all of the 5 children hiding from him because of that. So you want that kind of memory for your children? Didn't think you would. So that you need to fix it right now so that you don't have that. All right, then who's drawing the order?
I'll draft the order and submit it to Ms. Davidson for her approval, and then we'll do it. She can do the next one.
All right, then I will approve your agreement, and it comes in order to the court today, even though it's not a handwritten order yet, not a typewritten order yet, it is an order of the court.
Thank you. Thank you, Your Honor. I appreciate it.
We stand adjourned until 9 o'clock tomorrow morning when I have a criminal docket.
All right.
I'm sorry, that was my fault. Okay, this is.
Okay, we're gonna just head out. I'm gonna head out and let you guys.
Okay, yeah, just, that's what I was gonna give them here, so y'all can go, and then he'll be over at the house. Okay, sounds good. Okay, so we will get to.
Will you be here next one? We have.
Okay. 1 o'clock, okay, you're coming over, you got a few minutes, that's why I'm waiting.
If you're a few minutes behind, like, that's fine.
Yeah, yeah, so I'm gonna keep them here till y'all go, and then you'll take that.
Happy to my docket
Okay.
when I send it out. 'Cause I added you.
No, I'll be at the zoo that day.
Oh,
What a
the zoo,
fun time,
that'll
yeah.
be fun.
I love the zoo, dude.
Yeah, I
I'm
do
such a kid at the
too.
zoo.
Yeah. We're going, I think, we always go down.
Oh, I see it. Well, he is. I don't know if that camera has a microphone. But anyway, yeah,
Yeah.
I'm excited. I haven't been yet this year. I
Yeah,
usually go
it'll be
every year.
nice, yeah.
And now they got leopards. Everybody knows we like the zoos. Great. The internet's aware.
Have a good one.
Yeah, good to see you. I'll see you soon. You need a little basket. Your hands are so full.
Yeah. What we're trying to do is, like I said, but he says, look, I'm happy with her. She wants fine. So the person has to see what she can do. Yeah, then he has $10. But number one, houses, right, market for sale. If he's not gonna come up with her, she's not gonna. That's something so. Something else.